Your Lordship, the Chief Justice, Bart Katureebe, thank you for joining me for this interview.
You're welcome.
It's the first time that we get to interact with you after that famous petition of the 2016 general elections. At the end of your ruling, you did give recommendations, and many of these recommendations were similar to recommendations that were given in 2001 when Dr. Kizza Besigye went to court. You were not the Chief Justice then, but similar things, to do with the Electoral Commission, the entire modus operandi of our elections. Do you get the feel that these recommendations will be acted upon?
Well, first of all, with that petition, we handled it slightly differently from the previous petition. If you remember the one of 2006 where I was a member, we gave a decision. We didn't assign any reasons for our decision. In this petition, we decided we're not only just going to give a decision, we're going to give a deeper outline of our reasons for the decision. And then later, what we're working on now is a deeper explanation and analysis of our reasons. And we thought it important to outline at the end some of the causes of this perennial conflict of after-election petition. It has become now routine. And we think some of it is stemming from not attending to some legal reforms that ought to have been attended to over the years, as had been recommended by ourselves as court. So we have made a slight outline of what we are going to be coming up with longer and more detailed recommendations and how we think they can be handled.
I get the feeling that you have been interacting with those that are responsible. And my question again, do you get the feel that there is willingness to act upon these? Because it's not the first time that there's been talk about electoral reforms, for example. Just before the 2016 elections, there was talk about electoral reforms. Yes. And pretty much what we got as a reform was a change of name from Electoral Commission to Independent Electoral Commission. Very cosmetic, and so it's not the first time that this has been talked about.
I get a feeling now, talking to people and reading what's in the country now, the discourse, the debate. I think there is more willingness. I can discern more willingness to debate genuine reforms in the coming years with the proper dialogue and so on. I think there will be, and we will be making recommendations to that effect and suggesting on how we think it can be gone about.
After you did deliver your ruling regarding that petition, there were all sorts of reactions from experts in law, from lawyers, from newbies at law, reactions from ordinary folks that know nothing about the law. Yeah. Some thought, that was expected because they felt there was a shambolic performance by the petitioners' lawyers. But then again, there was the other school of thought that you, as the Supreme Court, did not dig as enough as you should have, and so they failed to just deal with the surface areas. How do you respond to that?
Well, as you say, an election petition is a very emotive affair, and at the end of it all, people come up with all sorts of things. And sometimes the basic things are overlooked. To me, the law is clear. You want a petition nullified, you want an election nullified. You bring your petition, you bring evidence that supports it. Because at the end of the day, the judges must be convinced that it is fair, it is just, not only for you, but for the whole country, that this election should be nullified. And the standards have been set in the law. And if you will remember, I allowed you, the press, to cover the proceedings live, because we wanted everyone to see what we were seeing in the court. The evidence as it came, the way it was presented, and so on. And we were convinced, and I'm still convinced, that the evidence that I saw in that courtroom, the way it was presented, did not convince me that I could nullify that election. Now, it is basically that. Was the evidence there? Was it convincing? We didn't think it was. Somebody else may think it was. There was, of course, a school of thought we say the court should have even gone out of its way to look for more evidence. We don't do that. We don't have the mandate to do that. We don't have the procedure rules to do that. So I think we handled the petition in the best way that we were allowed in the law.
There were discussions by some lawyers and other folks about Article 59, I believe it is, and some thought the way the Constitution is regarding petitions, it's very difficult for a petition to, for an election to be nullified because there is no very clear yardstick, as it were, and so it's a nebulous position, and that means the judge, based on their discretion and that kind of thing, the yardstick is not clear.
Well, of course, the yardstick, the one which is in the law, I think says that to nullify the election, the court must be satisfied that the malpractices, I'm just paraphrasing it, have affected the results in a substantial manner. That's the yardstick that is put in the
substantiality test, which again is not too clear.
Which is a matter now of interpretation, what is substantial, what is not substantial, what amounts to malpractice, and so on. Ultimately, you may need to do amendment in the law. If you want to lower the bar, you may have to do it by legislation, because that was introduced in the law.
Do you feel there should be legislation?
I think it should be looked at. I think it should be looked at, because if you say it is difficult for the petitioner to prove to nullify an election, what was the intention of the legislature? Did it go out to make it easier for an election to be nullified? Was that the intention of the legislature? Or they put the bar necessarily high so that if you really want to nullify an election, make the whole country go through the whole thing again, then the grounds must be such as to convince the court that really there's no other alternative. So I don't know. I think that's something that will be debated for quite a long time.
Finally, on this issue to do with elections, do you feel it's fair for a player, somebody that is going to participate in an election, to be the one to determine who gets to be on the Electoral Commission, to set the rules, etc., etc.? They are an opponent in this game, and they determine who the referee is, who the linesman is, and the like. Is that fair in your view?
Well, it's not a question of fairness. I think this is the sort of reform that should start to be debated. And I think if you read the judgment of Professor Kanyihamba in the 2006 election, he brings out that point, that we had a system, you remember the movement system, under which you had a structure and people were appointed under that system to run elections under that system. When the country went multi-party, there were no necessary legal amendments to take into account the changed circumstances, the changed multi-party system. So you continued to run the elections and everything as if you still had the old system, but you were actually implementing a new system. That was his argument, and I think there is merit to it. So this is some of the things that really ought to be looked at. Have we got it right? And so it's not really a question of fairness, it's a question of going back to the fundamental question. When we shifted from the movement system to the multi-party system, did we accompany it with the necessary legal structure to make sure that now things would move under the multi-party structure? I think that's a question that is out there, and people are going to be discussing reforms. We'll have to address it.
Let's talk a bit about the independence of the judiciary, which you had. There's been talk about the independence of the judiciary or the lack of it. The feeling out there is that the executive roughshods over the judiciary, which you superintend over. It bullies it, it muzzles it, and there's been concerns. For example, the ex parte rulings by your Deputy Chief Justice, His Lordship Kavuma. You know, he sits unilaterally and he makes these decisions. Of course, it's provided for within the law, but then there's a feeling that there's an invisible hand. You know, the executive pushes, because some of these rulings that have been made against, and yes, this ban did expire, opposition activities, and then we in the media, of course that expired, but there's concern that this could happen again.
I think all over the world, even in the United States or where, there will always be that, I don't want to call it conflict, but there will always be the executive wants to do something, and the law is a check. And the judiciary, which now is supposed to say, look, you are checked by the law, we interpret it this way. Sometimes there have been these conflicts. Recently, you have seen in the United States, the president attempting to nominate a judge for the Supreme Court. And for political reasons, the judge has not been appointed. And I've seen what some of the candidates saying, even if you are going to appoint a judge, there is a decision which was made by the Supreme Court which rubbed the executive the wrong way. And one of the criteria say the judge whom I will nominate must promise that he's going to change that, that decision. So this is always there. However, there are checks and balances within our system. A judge makes a decision. Now, nobody can swear that a judge will not make a decision that is wrong or that is actually against the law, you know, totally nullity. But they make decisions. Those decisions do get made. But what is the checks and balance? You appeal the decision, it gets upset. It gets reviewed. We have provisions for review, for revision, for appeal. All those things are there. So to pick out one decision that has been made by one judge as a basis to say the judiciary is not independent.
It was a landmark one which had so many consequences.
Yeah, but you see...
Well, not just political parties, but even we in
yes,
the media.
Yes, but exactly. And then what happened? When the decision comes out, what happened? You know, you choose to say, I am going to defy the decision. But if you are really a law-abiding citizen who wants to the rule of law, the law says, make a reference on that decision to a panel of 3 judges. And they will make a decision. And if that decision you are still not satisfied with it, you can still appeal to the Supreme Court. You remember when we had the case of the rebel MPs? Some of you in the press, what were you saying? Again, that the judiciary was being twisted and politically and so on and so forth. The Constitutional Court made their decision. These people appealed, and the Supreme Court reversed the decision. So which judiciary now would you be talking about?
Besigye wrote a letter to you addressing, you know, issues pertaining to this, and he feels that there's unfairness, especially to him as a politician, especially being that he's a part of the opposition, and not just him, but folks around him. And he talks about being arrested severally, being witch-hunted politically by judicial officers, by the judiciary. And again, there's that play out of, there's that hand of the executive pushing the judiciary to do things a certain way.
Well, I received Dr. Besigye's letter. I have answered him. And even before I received his letter, for us, we had already given out instructions that whoever is brought before us as courts must be treated strictly in accordance with the law. You must be produced before a court during the times which are stipulated, a court established by law. You must have access to your lawyers. You must have access to your family. You must be informed of the charges that that are being levied against you under Article 28 of the Constitution. Our job is to ensure that that is done. Whether it is Besigye today or Senyonyi tomorrow, it doesn't matter. Anybody accused of a crime, once he's brought before the court must ensure that Article 28 of the Constitution about fair trial is respected.
Why do we wait for a letter from Besigye for the judiciary to respond, to make statements on this? Because we don't get to hear this talk very often. It's only when Besigye writes and the letter goes public, and then you come out and say, look, let's respect the law. You talk to the executive and the like.
No,
that hardly happened before that kind of letter.
First of all, the law has been there even before Besigye was arrested. Article 28, we put it in the Constitution way back in 1995, and it has been applied. People have been arrested and people have been detained, and we have come out, people have been released on the orders of the court and so on. So it's not new that it's just reminding people that this is what we need to do. Because if someone now applies to court that want this case transferred from here to there, then we must say, what does the law say? Is it within the law? If it's not within the law, then we don't do it. So it's not that it's because Besigye has written. No, he wrote, so we had to answer it. But it's not that these are new instructions. The courts have been observing this since 95 when the Constitution came into force, or even before.
Does it bother you when, say, a court does release people and then immediately, almost immediately, and sometimes actually immediately, they get rearrested? Remember scenes of the Black Mamba siege at these very premises.
Of course,
we keep seeing bits of that again and again. Does that bother you at all, that you're trying to do your job and somebody is pushing you?
Of course, it bothers me.
What do you do about it when it bothers you?
Of course, it bothers me if anyone tries to act outside the law. And it should be bother every citizen, whether it is the police today or the army tomorrow or us judicial officers. If we act outside the law, it should bother everyone. And what we try to do is for us, first of all, to make the orders when we have to make orders, the necessary orders, to remedy the situation. That's what we are allowed to do. And outside making orders, engage the people who are making those type of mistakes to make sure that they don't do them. So when I say I have engaged members of the executive, this is to say, look, what you did is wrong. Don't do it this way. This is the way. If it comes to us in the court, we'll make the necessary orders. So you have to go on a two-pronged approach. If a matter comes before the court, you make the necessary orders. And we encourage the judicial officers to make orders as the law says, without fear or favor. Make an order. If the state is wrong, you say the state is wrong. And you know it very well. The courts in Uganda have made many times orders which rubbed the government the wrong way. You remember one decision which was made in the Constitutional Court, and the executive went out and said these judges are only fit to hear chicken thieves cases and things like that. We have seen this happening, but the judges have continued to make decisions. When you talk of Dr. Chiza Besigye, of course he has had this unfortunate confrontation with the law and so on, but is there a court that has ever convicted Besigye of a crime? Do you know of a court where Besigye has been convicted?
It's an interesting question. You asked that. Hardly any. Does that then mean you see that he's not being treated fairly, at least from the judicial perspective, and that is why anyway,
what it means is that when he has come to court, the courts have applied the law as they should. If there was evidence, they would convict him. If there was no evidence, they acquitted him. Or the cases were withdrawn. I don't know exactly what happened. But the courts have played their role. Now, the courts are not going to go out and arrest people. We don't go to arrest people to bring them to us. But we insist if somebody has been arrested, bring him before the court. When does the court enter into the situation? Where the law says any person, including you as a private citizen, if you have reason to believe that someone has committed an offense or is about to commit an offense, you can arrest that person, but bring him before the court. Once he comes before the court, then the court can remand him or can release him on bail or whatever conditions the court sees justified. That's when the courts come into it. Now, when the police go out and beat people and so on, those are actions which can again be questioned in court. That is the procedure as it should be.
President Museveni has said one too many times that bail for certain crimes should be thrown out the window. You know, he's talked about economic saboteurs. Of course, much of the time, without a doubt, he's targeting opposition politicians. Do you agree with him, with that school of thought?
I was part of the team that made the Constitution, and I think the Constitution should be respected. When we made the Constitution, we were coming from a situation where we had certain offenses that were not bailable. You could be charged with, I think, murder, rape, a number of offenses, and they were not bailable. So somebody could just put a charge on you, and all the court had to do was remand you for at least 365 days before you could you could come out. When we made the Constitution, we said there should be no such a thing as a non-bailable offense. Every offense should be bailable, but the judge should be able to exercise his discretion. Every person should be able to apply for bail, and the judge exercises the discretion whether to grant bail or not. And we went further to say where the judge exercises discretion by not granting you bail, but if you stay in the jail on remand for so many days without being committed for trial, then you must come out. This is in the Constitution. And there were good reasons why we put it there, as I've tried to say. So to depart from that, one would have to bring good reasons again why we must go back to the position that we had before. So for me, I'm not convinced about that.
You've talked about remand and the law, as you say, after a certain period and somebody has not been produced before court, they should be let go. That has not happened. We still see so many people that are in Luzira on remand. There's a backlog of cases. Many of them have not been before a judicial officer. When you came into office, you said this is one of the issues that you're going to tackle.
Yes.
You began by trying, but with all due respect, not much has been done, and we are wondering what's the plan?
Quite a lot has been done, and we are doing it. It is true, I have spent time visiting quite a number of prisons, and there are indeed people out there. And you ask yourself, why is this person still not tried? There are people who have been committed and they have not been able to be tried because we couldn't put together a session of court to go and start hearing those cases. We couldn't put sessions in place because we didn't have either enough judges or we didn't have the money for the courts to take place. Because you know criminal trials cost more than civil trial because you have to get together the witnesses, that's the state, you have to put there, you have to give the briefs for lawyers if their people are not represented and so on. So we have been having this tug of war. First, if you have a high court, which even by parliament recommendation should have 80 judges, 82 judges, and now you are still at 50, you are bound to have those bottlenecks. If you ask for money for hearing of cases and you are told there's no money, I had to fight very, very hard with the Ministry of Finance last financial year to get a supplementary of just 5 billion shillings, part of which we used to organize criminal sessions to address the sort of problem you're talking about. We have now just been given an increment in this budget. Our budget has been increased by just under 20 billion shillings. And we are going to spend a quarter of that on organizing sessions to address exactly what you're talking about. In the meantime, we have intensified our efforts at plea bargaining. Even as I speak today, this whole week, we have had experts from the University of Pepperdine in America, retired judges, professors, and students, who are here training our people in the prison. They have been in Katojo, in Fort Portal, they have been in Barara, they are in Bushenyi today, I think, training our judges and judicial officers on how to conduct plea bargaining so that some of those people who have been in jail awaiting trial, which trials are taking longer to come, can come out. So we are looking at a broad spectrum.
How about following the law, as you said, and let them go, some of them, especially those that have been there beyond a certain period, which you did stipulate according
yes,
to the
but
law.
they have
Why not let them go?
Yes, and we have a scheduled meeting with the Director of Public Prosecutions. We have, and he has asked the prison to write out the people who are in each prison so that we categorize and we see who is where and who is where, and we are going to be working on that. It's taking a bit of time, but as I said, it requires personnel, it requires money, and that's what's happening, and we are going to do it.
Let's talk about something else that is a monkey on the shoulder of the judiciary, corruption. The president himself, not once, not twice, has alluded to corruption in the judiciary, and several other members of society, Professor Kanye Hamba, and several other people. And there was a feeling that when you get into office, you're going to nip this in the bud. There's still a lot of cry about corruption in the judiciary.
You know what? I feel a bit of concern when people trivialize a big problem. It's not an issue of corruption in the judiciary. It's an issue of corruption in the country. It is not that when a good man like Senyonyi gets appointed a judge, suddenly he starts getting bribes. Where does Senyonyi get to be appointed from?
How about maybe putting checks and balances, at least where you're able to, where you superintend over, which is the judiciary?
Let's take it properly. If you have been a lawyer in private practice or in public service, and you have been operating corruptly, and somehow, for one reason or the other, you find yourself a judge, you are not likely to stop overnight, will you?
So why don't you use the stick against those judges that you're talking about?
Now, that's
because you're able to, you might not be able to against Senyonyi out there.
No, wait. Well, let's move slowly. You see, that's your problem. You want to run before you walk.
No, I think this is important.
You see, it is very important to put the issue of corruption in its context. Now, what can be done when someone has become a judge or a magistrate, and he's corrupt. You have to investigate them. You have to put them before the Judicial Service Commission. If you look at the laws we have today, the Constitution, the body charged with disciplining judges, let's start with judges, disciplining judges, removing judges, recommending the removal of judges is either the Judicial Service Commission or the Cabinet. For some reasons, the Chief Justice was removed from the recruitment or the disciplining of judicial officers in the Constitution. Yet the Chief Justice is the chief administrator of the judiciary, but he has no say in the recruitment or the disciplining of judicial officers. But as chief administrator, people give you complaints. You get a complaint. When you get a complaint, you investigate it. Starting point, you call the judge and say, I have received this complaint. What do you have to say about it? You as the chief administrator must be satisfied about the genuineness of the complaint. We do get some malicious complaints. Someone has lost a case and he says, this judge is corrupt. I could cite for you quite a number. And you have to deal with that. But if you are satisfied that this is a case that needs further inquiry, then you have to send it to the Judicial Service Commission. And there are bottlenecks there. You will have to go and check with the Judicial Service Commission how many cases that are waiting to be dealt with. But that is administrative bottleneck, that in the investigation and the trial of people accused of corruption, but this is not addressing the issue. The issue is, who are the people who corrupt our judges? Who are the people who will pick up a phone to call a judge because he's his relative, not even giving them money? Please, the case coming before you tomorrow, it is of my son, it is of my brother, it is of your aunt, look at it favorably. That's part of corruption. It's part of corruption. So that's why I'm saying, to confront corruption in the judiciary, we must do it hand in hand with attending to corruption in our society.
How do we deal with it? Let me pick your mind now as a senior citizen. The president has talked about fighting corruption. Yeah. Every year he talks about it severally. Yeah. And we don't quite see that action, even by what you are saying. Clearly, there's still a lot of it out there. So what do you think would be the remedy to this corruption?
Well, there is, first of all, the administrative one. In the judiciary, a number of cases of people who have been investigated and approved by the Judicial Service Commission. You have heard of magistrates who have been dismissed, some who have even gone to jail. I think right now there is one where I got information that this magistrate was asking for some money. I asked them to lay a trap for him, involve the IGG, which they did. They arrested him with money. The IGG is prosecuting him. So that's one way, dealing with it, both administratively and legally. But there is another way of dealing with it. Some of these things have to be done with, have to be attended to politically. If you are a political leader, you are a minister, you are a head of a department, and you are charged with a bribe, receiving a bribe, you are charged before the Anti-Corruption Committee. Even if you have been released on bail, in my view, now politically you should be sidelined. Don't come back to cabinet, don't come back to office until this matter has been resolved. Isn't that what we do with public officers? If you are a public officer and you are charged of a crime in the courts and you get interdicted, when you get interdicted, you get a half pay until the matter is resolved. And even after your interdiction is lifted, the public service may still dismiss you. Why don't we apply that even to political leaders if you want to really fight corruption? So that's why I'm saying, if you want to deal with corruption, let's deal with it as a societal problem. The people who ring us here, please, my case is coming tomorrow, are our relatives, are our family, they are our friends. And all that is part of corruption, isn't it? It's not just a question of where you have got money. Anybody who tries to influence you to reach a decision that you probably would not have reached except that is your friend or is your relative and so on, that's part of corruption. It's part of the bigger problem. Now, then you come to, I have told you, if somebody is a member of the bar, you are a lawyer. Who are the people who have the capacity to reach judicial officers to offer them bribes, if that happens at all?
You don't think it happens? You say if it happens at all?
No, if it happens that he's giving a bribe to a judge. But what we have also seen is that a lawyer will go to a client and say, I need 50 million shillings here. The judge needs 30 and 20 is my fees. And we have found that there are such cases where actually the judge knew nothing about it and the lawyer is getting money from the client, purportedly for the judge, and the judge knows nothing about it. So that's why I was saying, suppose that lawyer tomorrow becomes appointed a judge. What happens? So we have now to fight it also in the process of selecting people becoming judicial officers. When you are selecting people to become judges, do a background check. How have they been practicing? If they have been practicing, if they have been in public service as state attorneys or elsewhere, are their antecedents? So you have to do a proper background check. The Judicial Service Commission must do its background check. The Law Society, usually they are asked, must do their check on their members, because to become a judge, you must have been a member of the Law Society. They do that background check before we say so and so. The day after he had been sworn in as a judge, he has taken a bribe. People would ask you, what happened? What went on in his recruitment? When the names go to the president and the president sends them to Parliament, again we must look at how does Parliament go about it. What was the idea that Parliament should vet people who are being appointed to become judges? The Parliament itself should do a background check. They know us. If my name goes there, and someone should go to his MP and say, but this fellow comes from our village. We know what he has been doing here. Why shouldn't that information come up? So at the end of the day, we put in place a mechanism to make sure that people who come to the judiciary, I'm talking of the judiciary, I know it's true of other places, but of the judiciary, is that you go through a sieve. Your name goes to the Judicial Service Commission. The Judicial Service Commission is supposed to cross-check it and say, yes, this person is a fit and proper person. The name goes to the president. The president sends it to Parliament. Parliament is supposed to vet you. So by the time you go through this process, then we can assume that this is a person, because that is where you start from, that the people you put in positions of responsibility like this, we are sure of them. We trust them. And that system must be another starting point.
All right, let's wrap up with this, the pay of judicial officers.
Yes.
Of course, not too long ago, the pay of judges was increased, so they're a little bit comfortable, one would say. But let's talk about the low-ranking ones. We've been talking about magistrates. These people earn a niggardly salary every month.
Yes.
Could it be why some of them get bribes as, little as 100,000 shillings? Those cases have been addressed. Of course, even the rich can steal, and we have seen them stealing. Does this low pay of your judicial officers bother you at all? And if so, what are you doing about it?
It really bothers me a lot. It's something that we have written about, something we have engaged the executive, including the president and the Minister of Finance about. And even studies have shown the correlation between payment, financial security of judicial officers and allegations of corruption. Studies internationally have been made. One way of ensuring the true independence of your judicial officers, and as you say, especially of the lower cadres, is to make them financially stable. If someone is wanting in his financial security, it is possible there may be a greater temptation on that part. Those studies have been there, and you find that in some other countries, the first thing they do is pay their judges very well. Their judges and other judicial officers very well. So the judges, yes, they got a little more in terms of their housing allowance and so on. But if you take a law graduate from Makerere, and he has gone to Law Development Center, he has finished, he has come out, he wants to make a career in the judiciary. You appoint him a grade 1 magistrate and you pay him 1 million. And his colleague who goes to KCCA or Bank of Uganda or Revenue Authority gets 4 or 5 times as much. You create that disparity and the discontent and so on. That's part of the problem that you have, which must be addressed. And we have asked government to address this. Of course, the answer is yes, we should address the judiciary concerns, but right now it's not a priority. We have other priorities and so on. I have been trying to argue that the judiciary must be priority number 1, because administration of justice in the country is a sine qua non for other things to follow. Administration of justice is a sine qua non to in attracting investment. It is a sine qua non to economic development. If people are enjoying the rule of law and the administration of justice is working correctly, people will trust this country more than they do today. It's not a question of commercial justice. Even what you have been talking about, to have so many people in jail, who should have been tried and were not tried because the cases couldn't be financed, because the courts couldn't find money to have a session running, or not appoint enough judges because the treasury cannot find money for their salaries and so on. So what does it mean? If I am an investor and I want to bring money here, and tomorrow if I run foul of the law, and I don't know how long my case will remain in the system, do I get that confidence? So fortunately, we have been able to convince even the president. I think he has made instructions to that effect, that the judiciary should now start getting prioritized. We have talked to the Minister of Finance, the chairperson of the National Planning Authority, people, and the Parliament. Of course, you have seen, I have been meeting members of the parliamentary committees. They are more supportive. So we think we are going to be moving. And as a starting point, we got an increment of 20 billion shillings this year in our budget for our operations. It is still a drop in the ocean, but I think it is something that is a bonus for us. And as I indicated, a quarter of that, we are putting it to criminal cases that have been backlogged for too long. We want to try and start moving on that.
Your Lordship, the Chief Justice, thank you for talking to us.
Thank you very much.